Good afternoon and welcome to the Children and Family Affairs Subcommittee meeting for February the 3rd, 2026. Before we begin, I'd like to remind the members to sign into the meeting using your microphones if you haven't already. And then I'd like for us to begin with a prayer. Representative Kiesling, would you lead us in prayer, please? Could we all stand? And remain standing for the pledge, please.
Heavenly Father, we again come to thy throne of grace and mercy today. Thank you for another day of health. Lord, for those that are suffering, Lord, we just pray for them. And Lord, we just thank you for this committee, for those that are attending today. But give this committee the wisdom and the fortitude to vote in their respective ways and the way they feel today, Lord. And we just pray for those that are still hurting and still without power throughout this community and throughout other areas that you see, Lord. We just pray for their recovery of their power and of course, Lord, their losses as well. These things we ask in thy name. Amen.
Amen. Would you join me in the pledge, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Madam Clerk, would you please take the roll?
Oh, yeah, I was waiting to say
I hit it hard. Clerk, would you please give us the roll, please?
Madam Chair, you have 6 members present. You have a quorum.
Thank you. Before we get to personal orders, I'd like to make a couple of announcements regarding the operation of this committee. First, members must be recognized by the chair before they can make a call for the question or make any motions or anything. Additionally, we ask committee members presenting bills before the committee to do so from their seats. This will allow you to vote on your own bills. So, members, do we have any other personal orders? I guess so. We will hear after our bills. We will hear a presentation from the Juvenile Justice Review Commission. But first, we have 3 bills on our calendar today. Some housekeeping. Item number 1, House Bill 1263 by Representative Slater has been rolled to the special calendar to be published at the final calendar. With that, we have 2 bills left. First bill is number 2, item number 2, House Bill 1235 by Representative Love. Properly motioned and second, and there is an untimely amendment that just changes the date. Members, do we want to accept this amendment?
Second.
All those in favor say aye. Aye. Those opposed? Okay, so the amendment will go on. So the amendment just changes the date, so we need to. Right, that's awesome. So now we need to adopt the amendment. So we'll be voting for on the amendment to go on. What's the amendment? To go on House Bill 1235. All those in favor say aye. Those do we do that on the thing? I don't have. Where is it?
It's right there.
Drafting code 1239.
1239.
1239.
19.
Let me see that again. Where is it? Right, 12319. I'm sorry. We're new at this again, so it's like starting over. So all those in favor of adopting Amendment 12319 to House Bill 1235, please say aye. Aye. Those opposed, no. So you are recognized on House Bill 1235. You are recognized, y'all just bear with me, we'll get to it. You are recognized on House Bill 1235 as amended.
Thank you, Madam Chair, and thank you, members, for your patience as we were working on this piece of legislation last year and had to defer to this year. Present law prohibits a court from directing the Department of Children's Services or its contracts or agents use or disposition of federal funds for which any child or person in the care of the department is eligible for that child's benefit. And what we found is some of the funds that children who are in foster care would be receiving from their parents who are deceased or otherwise unable to provide service for them, the funds that these children were receiving are being captured by the state and being used by the state, and the child is not able to access those funds. This piece of legislation authorizes us and the department to not do that anymore and to set aside some of these funds so that children can have those funds available for them. The bill authorizes the department to exercise discretion to conserve these federal funds in the best interest of the child by holding such monies in a trust or apply for and establish an account for the child, including a plan for achieving self-support, a 529 or 529A plan, an individual development account, a special needs trust, or a bank account. However, if it's in the best interest of the child, the department may utilize the federal funds for special needs services that are not currently being provided by the department. The bill also requires the department to conserve and use the federal funds in a manner that does not violate any federal asset or resource limits that would affect the child's eligibility for benefits or assistance offered by the federal, state, or local government. And so what we're really trying to do is make sure that children, again, who are in foster care, but do have funds that are available to them, like Social Security survivors, would not have, or veterans benefits, or railroad retirement benefits, or Black lung benefits, or any successor entitlements that are provided by the federal law, would be able to have access to those funds. And we do know that, of course, there's some children in foster care who don't have these benefits. Of course, the state does pay for their care, but our concern is that there are children out there who do have these benefits available to them, and they're falling into the category where the state is using these funds to provide care for the children, and then will exhaust these funds at a certain point. And that, Madam Chair, members, is the synopsis of the legislation.
And I do think, thank you for that explanation. I do think we have some witnesses that want to testify from DCS. If you would come forward and state your name and who you're with, please.
Thank you, Chair Lady and members of the committee. My name is Jim Lehman. I'm the Legislative Director for the Department of Children's Services. I have with me Hayes O'Donnell, our Assistant Legislative Director. The department has a position of working with sponsor on this legislation. So the bill would require the state to replace revenues that would be lost if this bill were to pass. So currently, if you read the fiscal note, the state collects around $7 million in these funds. And those funds are used to provide for the care of the children, that come into our custody that would otherwise be eligible for those funds. Beyond the fiscal note portion, the concern that we have, and we just want to be sure that the committee's aware of it. So we in concept have no issue with the idea of conserving these funds, to provide to these kiddos when they become of age, assuming the revenue's replaced. But the one concern that we do have is these funds impacting their eligibility for other government assistance programs. I don't know that there's a way for the state to tell the federal government that this is not income if the federal government has laws about what is and what is not income for the purposes of their federal aid programs. So our concern is that this will be more harmful than helpful for some children, not all children, but for some children that get a very large amount in these funds, that it would disqualify them from like TennCare and SSI and other government programs. Happy to answer any questions you may have.
once they turn 18 and they are allowed to stay in the foster system now until they're 23, and I think a few of them may be 25, what happens between 18 and 23 for those children?
Well, so currently, Chair Lady, we do have our extension of foster care program. It's actually recently been renamed our Bright Futures program. And I believe this, again, having these funds count as income for the kiddo could affect their eligibility. Do you want to speak to that, Hayes?
Hello. Hi. Hayes O'Donnell, Department of Children's Services. So I believe as the bill as written does not necessarily address a transition for that. One of the things that we'll need to make sure of that in any account that we do not exceed that limitation. And then the youth or young adult at that point after the age of 18 would need to ensure that they do not exceed that account limit. Oftentimes that is $2,000 for most accounts for Social Security, or they could run the risk of losing those benefits. Some of those benefits do include, TennCare, Medicaid, the Choices program, which can offer housing, transportation, job services, various items. Those services are extended if they are disabled. And I can provide a more extensive list for those, but that would be under the Choices program as well.
Okay, I have one more question. So after they turn 18, will they still be eligible for the income that's coming in as our children? Will that end when they turn 18, the benefits that they're receiving?
As far as I know, Chair Lady, I wouldn't think that we wouldn't continue to receive those funds on their behalf if they're 18 and no longer in our custody, right? If there are funds that they're still owed, they would just receive those directly. Now, this would impact any of the funds that they were owed while they were under 18 and in our custody.
So they wouldn't age you out of that money that's coming? I guess it would depend on what's coming in.
Yes.
So like if it's Social Security from the death of a parent or something, would that end at 18? Or would it be extended if they go to college? Do we know that? Or I should have been asked that while you're
well,
in my office. I'm sorry.
I don't specifically know, Chair Lee, it may vary depending on the type of situation. I don't know if they receive it, but I think this bill would impact the benefits that you receive while you're under age 18. I don't know if there are situations where a child would have been entitled to funds under 18 and over 18, but this bill is about the ones that they would have received while under 18. Yeah.
Thank you. Are there any, I think we had Representative Harris first. You're recognized.
Thank you, Chair. So with that being said, are there any things that could be, in order for this to be done, are there things that could be done on our end to make this happen?
We are happy to keep looking into those. Again, I don't think the state can tell the feds, what, program eligibility looks like. I think it's up to the federal government to determine that. I think we are sort of exploring, and very early, we don't have the answer yet, but we'd like to talk with the sponsor about, hey, is there a way to say, well, if the funds are so high that they would disqualify you from government programs, then maybe those funds don't go to the kiddo, because if they went to the kiddo, then they would be disqualifying, right? So let's say maybe a max of like how much you could get just to ensure that that you're not disqualified from other programs that may be more helpful to you than those actual funds.
Representative Harris.
Thank you.
Good. I think we have Representative Towns next.
Thank you, Madam Speaker, and thank you for your presentation. The problem seems to be that it's classified as income. So what if we reclassify it as a stipend or something of that nature that's not income? How does that impact? Because stipends are not considered as income when students get stipends. So it's how we're classifying it.
You recognize.
Yes, I think it's not how you recognize it, it's how the federal government recognizes it. So I think you'd have to, if you could convince the federal government to do that, yes. We ran into similar issues with the relative caregiver program. Was not something that was intended to be, counted as income, but again, it wasn't up to us. It was up to the federal government, what it is and isn't income. And so if we could, if there was a way for the state to say, hey, this is a stipend, we'd be happy to explore that. Again, it's our belief that it's up to the federal government to
Well,
decide.
Representative Towns.
thank you very much. What I think is that we should explore it, okay, as opposed to letting them dictate to us. We take the leadership and tell them what we're doing in Tennessee, okay? Secondly, if we categorize it a certain way, it protects them because these are some of our most vulnerable citizens that have been in our care for an extended period of time, and for them to be kicked out and not have any money at all, that's cruel. That's very cruel. So what I'm saying is what we need to do is get our lawyers together and figure it out, okay? You can't be afraid of the federal government. You afraid of the federal government? I got something for the federal government right here. How about that? Okay, so we have to figure out how to help people. We want to help our kids, young people, we need to do it. The other thing we've done in the past with the healthcare concerns, Tennessee's asked for waivers, okay? So there are a couple of options out there to figure out how we can help. Because for me to be in foster care, 18, 23 to sit under, they just get kicked out. What do I do? What do I do without some funds? It's not good. And we know it. So we got to fight a little harder, in my opinion. We need to write a letter to the federal government. This is we're going to classify the stipend, this, that, and other, and this is what we think it ought to be. Should be considered income. After that, right there, and there should be no hindrance of them being able to still participate in these programs. Simple. And let them suckers say no. If they say no, you go down there and see them. Take your crew with you, and you debate it back and forth to try to help our kids. So what I would love to see is love and you all and the rest of us being on the same page trying to help the young people. That would make it work, in my opinion. Madam Chair, that's all I have.
Representative Alexander, you're recognized.
It's my understanding on how DHS works. We get funding from the state, we get funding from the federal government. You got two different pockets of money. And how do we decide which goes into what, which comes out of what? The other thing is that I know Representative Townsend said something about that it was unfair and that we're taking the people's money, but the kids have gotten services under DHS custody. Somebody's paying for that. And so I want to make sure that I do think, like Representative Townsend said, we need to keep working on this because I don't think the way it's laid out now makes sense for us to vote on it, because I think it would cause us more problems, more confusion. I know but I'm just saying, even if we rolled it, and I don't know if we can roll a bill that's held over. It goes to the special calendar. But if we do that, that would give us time, correct, to work on this, because I don't want any kid whose parents have left them money not to be able to get that money, just like you all don't. But at the same time, there has to be a logistical way that we get to this point and that we can actually do this. It might not work in our system. I don't know. But I'm willing to keep hearing and listening. So anyway, my comment, sorry.
Chairman Doggett, you're recognized.
Thank you, ma'am. It was, I think, previously stated it was going to be a question I was going to ask for the sponsor on this, but about under this proposed legislation, there would be, it would create a reporting requirement for parents or guardians of these children for tax purposes under this. This would be counted as income. Is that what I understand?
Mr. Lane.
Yes, that's how we read it, that There's no avoiding counting this as income for the purposes of the kiddo, what their income is, which would be used to determine eligibility for other government benefit programs.
You're recognized.
And then my follow-up question to that, and it may have been asked already as well, but when that child hits 18 years old, if there is some monies that are sitting there in this account for this child, if they were to receive 1 cent more, or maybe if they picked up some kind of job or something where they were generating revenue in addition to what they had in this account, would they then lose those wraparound services that may follow them on up to age 25, maybe it is?
You're recognized.
Yes, sir, that is correct. So even if that account is transferred under or at the maximum allowed amount, if that child or young adult at that point after the age of 18 continued to put funds into that account, it would knock them off of that eligibility.
Okay, very good. Thank you.
Representative Keesling, you're recognized.
No,
You're good. Chairman Volso, you're recognized.
Thank you, Madam Chairman. Mr. Lehman, my question is about the current practice. I understand from your testimony that the department handles something in excess of $7 million each year for payments that are made to, as you call them, kiddos who are under your care and jurisdiction. What is the current practice at the department as to the use of those funds, that $7 million?
You're recognized.
I can give a very brief overview, and to make a joke, I'll put it into layman's terms. And if you guys want more details, we'll switch it back over to Mr. Lehman. So SSA and SSI do provide very strict tenets on how these funds can actually be applied. So most of those, meaning the food, shelter, housing, or clothing, direct resources to care for that child. And those resources also do follow the exact child that it is being pulled from. I think that is the most simple way to kind of paraphrase the use and collection of those funds as well.
You're recognized.
Thank you, Madam Chairman. So as I understand the fiscal note, the fiscal note of $7 million comes about because the funds are currently being used by the department for the care and services of the child. But if this bill were to pass, then the state would be responsible for that $7 million or so in care and services, and the money that comes from the federal government would be placed into a 529 or other investment account. Is that correct?
That is correct.
Representative Harris, you're recognized.
Yeah, I know we've talked about it, but what are the options for hearing this bill again? Is it that we have to, it would only be on the special calendar, or can we roll it a week, or?
It will go on the special calendar. He can't roll it again. Be special calendar. At the end of the year.
Be published in the final calendar.
Well, let move to roll it to the special calendar. Oh, once back in session. Okay.
Okay. Representative Alexander, do you have another question?
Make sure that that 7,637,000 or something close to it would be reoccurring every year that the state would need to come up with.
Right.
You're recognized.
Should be. Yes, that's my understanding, the fiscal
Okay.
note that, now that, amount varies a little bit from year to year,
Depending on how many
depending the kids that we
children you
have and their individual
Sure.
situations, but
Yeah.
that's the best estimate is around that number. Yep.
Thank you.
I have one more question too. Like if they're getting Social Security that ends like on the 18 on their birthday. So would they be allowed to stay in till they're 23, still stay in DCS custody or foster care?
I can go back and double check with our people to confirm that they can stay in, but to Representative Towns' point earlier, for children who age out of care and are part of our Bright Futures, or previously known as Extension of Foster Care, we do have a stipend that you all graciously fund that helps support those young adults to the age of 23. And that is a separate fund from the Social Security. But I will go back in and make sure that any other additional supports are not, crossed out by that. But items like SNAP, Section 8 housing, if we do have young adults that are eligible to apply, we do assist them with that process just to make that next walk in life a little bit easier. And if they do exceed those limits within the 2,000 or whatever their account allows, they could lose access to those portions.
Are there any other questions for DCS? Seeing none, are you ready to go back into session? So we are back in session. Representative Harris,
I'll let them say something.
Oh. Representative Love.
Oh, thank you. Thank you, Chair Lady, and thank you, members. Certainly, we know that having children in a situation where their parents are not there to help raise them and to give them guidance is difficult. When there are dollars available from the parents and the child does not have access to those in their formative years, that even worsens the situation. And so I don't mind working with the department. Look forward to have more conversations because I think we all just want to get to a solution to find out how we can best help these children either have some money and again, a 529 plan, if they want to go to college or some other vehicle that does not disqualify them from other programs, but certainly want to make sure that we are doing the very best we can by these particular children. So I'm open to the committee's recommendation, either for a role or listen, if you want to pass the full committee and we discussed it there, that's another option I think we have. I'm sure to open to that one as well.
Representative Towns.
Thank you, Madam Chair. Well, Representative, certainly I appreciate the bill and I understand the constraints that we may have. Certainly I'd love to see, everyone working with the department because these kids have nothing. Sometimes these kids have no parents. The parents died. I mean, by the mercy of individuals, they are being salvaged and saved because people care a little bit, but some of them don't have anything at all. I would hate to have grown up in that environment. Okay, that's a painful thought for me to think how I would have been able to navigate and where would I be today. Well, that's happening every day in this country, every day in this state. So, and then you have the other situations, the scenarios where people, whatever, maybe a drug addiction, maybe, you hadn't seen the dad and just whenever. And then you have an innocent child here that we've kind of stepped in as a surrogate and nurtured for a certain period of time. And then after that, we just cut them off like they never existed. That's kind of cruel. So yeah, I would love to see us working with the department and the feds. I would hope we would have a liaisons at the federal level to figure out how we can do this and accomplish both, abide by the federal laws as well as, help the young people. I think it's that's just a wise idea for us to try to assist these people because if you push and these people are not included in a pathway, but we know what that ends up like. It ends up like crime. It ends up like a lot of
Representative Love, did you have something
underused.
you wanted to add?
Just a question for legal. If rolling to the special calendar, would that allow us more flexibility if we had to bring an amendment?
Yeah.
Okay, then I'm open to that. Sorry, Representative.
Oh, no, very legitimate. But I don't have to say anything else. You know where I am, and I hope some of the committees here, we just want to try to help our citizens, help our kids, and hopefully be a part of the factor that makes them productive young person after they transition the system. So thanks for the bill. I'll sign on to it too.
Thank you.
Representative Harris? No, we don't. Well, I do want to ask a question too before we go forward. So I'm stuck on this when they're 18 and then they can stay till they're 23. So that's 5 years that they get to go to college and try to become productive citizens along the way. So will that all end if they get that money?
Great question. I think that's what we need to work out because it's my understanding that some Social Security benefits end at 18. But if a child has been allowed to collect those and have it put into a 529 plan, then that becomes a plan for paying for college. Other benefits may end at that point, and I certainly don't want to have a situation where the income from that disqualifies them. I'm not sure if the 529 plan would disqualify them from other programs in DCS coverage and foster care coverage. at that stage, I'm not sure.
I guess my point is, I would hate for them to miss that extra 5 years of being in some, being with DCS
Sure.
and getting their college degree and becoming, that's my concern, because we worked really hard on getting that set up. And so we want that to be available to them.
Yes, ma'am.
So, okay.
And to that degree, I don't know at what level Tennessee Hope Scholarship plays into that for those who would choose to take advantage of that, or Tennessee Promise. I don't know what that plays into that is either.
Okay. So are there any other questions? Well, who made it? Okay. Well, then, are we ready to vote?
To
There's no motion. No one's
Oh.
made a motion.
I think there was a roll to the. Yeah.
Representative Harris, you're recognized.
Move to roll this to special session, a special calendar.
Yeah, not special session. I don't. That's right there. I don't want to do that. I don't want to do that.
So, second, okay. I'll properly motion a second to roll to the special calendar to be published with the final calendar. So do we put that on the board? All those in favor say aye. Those opposed, no. The ayes have it. So your House Bill 1235, as amended, is moved to the special calendar.
Thank you, Chair Lady, and thank you, committee members. We will be working with DCS and also my Senate sponsor to make sure we get some answers, and if we need to, get an amendment that'll shore up some of this information for you. Thank you again for your
If you
time.
could find out that information, that would be great
ma'am.
too, because we don't want to lose that 5 years that could really be helpful to them.
Absolutely. Okay. Thank you.
Okay, next we have item number 3, House Bill 1473, Representative Bolso.
Second.
Properly motion and second, you are recognized, Representative Bolso.
Thank you, Madam Chair. Members, this is House Bill 1473. It's a simple bill that simply clarifies existing law. Many of you will recall that in 2015, our U.S. Supreme Court issued its decision in the Obergefell versus Hodges case, which struck down Tennessee's law regarding traditional marriage, as well as the provisions in the Tennessee Constitution that provided for traditional marriage. This bill simply clarifies that both the 14th Amendment, on which the Obergefell court relied, and the Obergefell decision itself apply to public actors, that is, to the state and to other governmental entities. It does not apply to private citizens. And with that, Madam Chair, I'm ready for questions.
Are there any questions for Representative Bolso? Representative Harris, you're recognized.
Thank you, Chair. So I'm just going to read it just to make sure we're on the same page here. Private citizens and organizations are not bound by the 14th Amendment or by the Supreme Court's purported interpretation of the 14th Amendment in Obergefell versus Hodges, 576 U.S. 644, 2015. And no private citizen or organization in this state is required to recognize a marriage or a purported marriage between individuals of the same sex, notwithstanding any other law. That's the main piece of it. And I want to start there and just ask a couple questions, if you don't mind.
You're
Sure.
recognized. Oh, you want to start with questions? Okay,
Yes.
you're recognized.
All right, thank you. So one of the things, Representative Bolso, that I've, in reading this, I don't look at this bill as being something that's about religious liberty, but about just figuring out a way to write discrimination into our Constitution. And so one of the questions I had for you was, are you asserting that the Tennessee General Assembly has the authority to nullify a decision that was made by the United States Supreme Court?
You're
No.
recognized.
So if you're not wanting to nullify a decision that was made by the Supreme Court, what is the goal in actually passing this piece of legislation if we can't supersede what the federal government has already done?
You're recognized.
Thank you, Madam Chair. Representative Harris, it's what I stated earlier. It's to clarify the law, not to change it. In Obergefell, the Supreme Court, found that the due process and equal protection clauses of the 14th Amendment provided a constitutional right to marriage to individuals of the same sex. The due process clause, of course, says no state shall deprive any person of life, liberty, or property without due process of law. So that the 14th Amendment itself applies to states and to political subdivisions. It has no application to private citizens. And sometimes there's confusion about that. And what this bill, HB 1473, simply does is it recognizes the authority of the Obergefell decision, but it also recognizes the limitations of the Obergefell decisions. This is not an attack on Obergefell. It recognizes Obergefell as the law of the land. It simply recognizes that that decision, as all interpretations of the 14th Amendment are applying to public actors, not to private citizens.
Representative Harris.
Yes. So in that same statement, give an example of what this bill, if it was to pass into law, what it would do differently than what Supreme Court has already done. What will it do specifically that's different?
You're recognized.
Thank you, Madam Chair. Well, that's the point. It doesn't do anything differently. It simply clarifies. This does not change the law. Nothing is different. It simply clarifies and allows Tennesseans to understand that this decision in Obergefell applies to the state and to political subdivisions. It does not apply to individual private citizens.
You're recognized.
So if as a private citizen, if I, or an organization, because you said private citizen, but you also have to realize it also mentions organization in here. So as a private citizen or an organization, I can in turn, if this passes, not acknowledge or choose to recognize what the Supreme Court has done, correct?
You're recognized.
Thank you, Madam Chair. That is true today, and that will continue to be true if this bill is passed.
And if a
Recognized.
private actor isn't bound by the 14th Amendment, as your bill is claiming, would you support a business refusing service to interracial couples?
You're recognized.
Thank you, Madam Chair. No, I would not support that. You have to understand that the 14th Amendment is one source of law. Title VII of the Civil Rights Act of 1964 is another source of law. And Title VII of the Civil Rights Act of 1964 prohibits discrimination among employers, public accommodations, and housing on 5 bases: race, color, religion, sex, and national origin. So all of the discrimination laws that we have in force at the federal level remain in place and are not affected one whit by this bill.
You're recognized.
Thank you, and I appreciate you for acknowledging these questions. Can you point to any constitutional analysis showing that this bill would survive an equal protection challenge under this section?
You're
Yeah,
recognized.
thank you, Madam Chair. So the question is, can I cite a Supreme Court decision that would support the constitutionality
That would
of this
support
bill?
of this bill if it was to pass?
I think Obergefell would support it.
You're recognized.
So if you're saying that it would support that this is going to be capable, how would that be the possibility if we've already passed it, if the Supreme Court has already passed this? If this is not going to change anything, right? You said it's not going to change anything about what they've put in place. All it's going to do is specifically for private actors and organizations. So how would you be able to defend that? And if we had to go to court on this one, how would we defend this?
You're recognized.
Thank you, Madam Chair. We would defend it on the basis of the history of the Supreme Court's jurisprudence on the 14th Amendment. I mean, the fact that the 14th Amendment applies to public actors, not private actors, is not unique to Obergefell. It applies to all 14th Amendment decisions. There would be numerous precedents to support that.
You're recognized.
And what about the organizations that take federal funding? Would it affect them in any way?
You're recognized.
Thank you, Madam Chair. If you're talking about a Tennessee organization, a private entity that takes federal funds of some kind, Representative Harris, The short answer is it would depend. I mean, it could be that a private entity is taking federal funds with strings attached, and one string might be compliance with Title VII of the Civil Rights Act of 1964. In that event, then whatever private entity who takes those public funds from the federal government would have to comply with Obergefell. But if you're dealing with a private association or private organization that takes federal funds that do not have strings attached to them, then it would not be subject to the same limitation.
And my last question, since 2015, has there been any incidents where this piece of legislation would be necessary in the state of Tennessee?
Thank you, Madam Chair. Yes. I mean, there's been a lot of confusion about that. There was a famous, I think it was a 2018 decision that came out of Colorado regarding a baker baking a cake.
In Tennessee.
Excuse me?
The state of Tennessee.
You're recognized.
Has there been any cases, matters, or issues that have taken place in the state, the volunteer state, the great state of Tennessee?
You're recognized.
Thank you, Madam Chair. I'm not aware.
Great. Thank you.
Are there any other questions for Representative Bolso? If not, are we ready to vote? Representative Harris?
So,
One more question.
no, not really so much of a question, but if possible, I want to ask if we could just move this to summer study, so to allow it to be studied on if this is something that we actually technically do need. And I'd rather us make that as a first motion before we move on.
So he made a motion second, and it'll have to be on the board since it's final action.
Okay. So we're going to be on the board whether to send House Bill 1473 to a summer study. So would you please open the board, clerk? Madam Clerk, would you please take the vote?
Madam Chair, you have 2 ayes and 5 nays.
Thank you, Madam Clerk. So your motion fails. Right. So are we ready to vote now? Question's been called. Well, you're going to have to raise your hand from now on, and I'll call on Representative Kiesling. You are recognized.
I call for the question.
Question's been called. Clerk, would you please open the board? So all of those in favor of House Bill 1473, moving on to judiciary full, please vote yes on the board, or I guess on the green, and no for no. Has everyone voted? Does anyone want to change their vote? Madam Clerk, would you please take the vote?
Madam Chair, you have 5 ayes and 1 nay.
Thank you, Madam Clerk. So House Bill 1473 moves on to judiciary full. So now we have, we're going out of session because we have a presentation. So we're out of session. So today we have, let me get your professional name so I don't call you my friend.
My friend is worse.
My friend, Mr. Craig Hargrove, is going to give us a little summary of what the juvenile justice, I call it the second look, it has another name, but anyway, we worked hard on getting this and we think we've got it semi-right. So it's similar to the second look commission that we do for the DNN. So I think it's going to be very beneficial to us in our juvenile justice. So you are recognized. And thank you so much for being here.
Thank you, Madam Chair.
Hey, could you state your name and who you're with for the record,
I
please?
sure will. My name is Craig Hargrove. I work for the Tennessee Commission on Children and Youth. I first want to thank Chair Lady Littleton and the subcommittee for giving me the opportunity to share the work and the plans of the Juvenile Justice Review Commission. As a quick note, we've already held 2 meetings. Our first meeting before November the 1st of 2025, which was required by statute. And then we had a subsequent meeting on January the 9th of this year. And so we are well on our way in doing what the statute requires. Just very quickly, I want to give you an overview of the Tennessee Commission on Children and Youth. The Tennessee Commission on Children and Youth is an independent, nonpartisan agency created to ensure the state's policies, programs effectively promote and protect the health, well-being, and development of children and youth. We're established as a permanent commission. We are the centralized information resource and advocacy agency for timely, fact-based information to aid in policymaking and coordination of resources. We do that through data and insight, collaboration, policy advocacy, and public awareness. Now to the Juvenile Justice Review Commission. And so the Juvenile Justice Review Commission is appointed and created to review an appropriate sampling of cases. And so the appropriate sampling of cases falls into two separate categories. The first category is when a youth has a second or subsequent adjudicated delinquent act. The second category is when a youth has one adjudicated delinquent act and is also involves a systemic concern. And so I'll define that in a minute. And so those are the two categories where we have statutory mandate to review an appropriate sampling of cases. Now, there is another set of cases where we have the permission, we have the right to, the discretion to review, and that's cases are involving cases where there is a critical incident. And so I'm going to define first the systemic concern, and then I'm going to define a critical incident. And so with the systemic concern, keep in mind, this is where a youth has one adjudication, then has one of these factors also involved in their case. And so the first one is DCS places the child outside of the state based on lack of resources. That's one category. The second is the child has an intellectual disability diagnosis and is placed in a hardware secure facility. The next one is when a youth is transferred to the Department of Correction pursuant to the incorrigible statute, youth incorrigible statute found in 37.5.206 subpart A. And basically that means a youth that's in between the age of 18 and 19 is in a YDC, has committed offense that would otherwise land the individual in penitentiary. And the superintendent of that YDC says this individual can no longer stay here for whatever reason. Then the commissioner of DCS and the commissioner of the Department of Correction come together and make that decision of whether or not the youth can be transferred. And so that's what that's about. The next category is delinquent youth is held awaiting placement for more than 30 days. And the last systemic concern is a youth has experienced what the statute calls placement insecurity, which is basically defined by they've had 3 or more placements within a 6-month period. And so those are the cases where the statute says we have to review an appropriate sampling of cases. And I'll talk about what an appropriate sampling of cases is here in a minute. So now to talk about those classes of cases where it's not mandatory but permissive for us to review, called critical incidents. And so these cases, again, there's 5 separate categories. The first one is an escape by a youth from a youth development center or a youth detention center. The second category is where there's been an act of aggression by the youth toward DCS staff or some other individual. The third is where a youth has committed an act of self-harm. The fourth is when there is an allegation, and I want to make that distinction. If you look above, the act of aggression and the self-act is contingent upon the act. This one is contingent upon the allegation of abuse by a DCS employee against a youth. And so that's the fourth category. And then lastly, involving the need for psychiatric inpatient treatment by a youth in the custody of the department. So that's the universe of cases that we must and are allowed to review. And so what we are mandated pursuant to statute to do is to produce a report with findings and recommendations that touch on all aspects of a youth being adjudicated delinquent and the investigation that goes into having that youth adjudicated as delinquent. The statute calls for our first full report to be ready no later than January 1, 2028. The statute says that before or on January 1, 2027, we have to provide a progress report. Thanks to the leadership of Chair Lady Littleton and the collective wisdom of our multidisciplinary commission, I think we're going to be on track to provide a preliminary report by the end of this year, as well as a progress report. And so we're moving well along those lines. So how do we get the cases that we review? The statute mandates that DCS is provide us a list of cases that fits those statutory definitions on or before October the 1st of each year, and it's based on a fiscal year. And so the previous fiscal year. And so DCS will go through their data and documentation, pull those cases, and those cases are sent to me or the Tennessee Commission on Children and Youth, and then we make decisions regarding how we will review those cases. But that's how they come to us and will come to us on an annual basis. Since during our last meeting in January, we talked about how we want to review our cases. It's still a work in progress. The statute provides that we have to, or we should not review more than 10% of the appropriate sampling of cases that involve the second or subsequent incident of delinquent adjudication by the same youth, and then one adjudication and a systemic concern, no more than 10% of those. And then it gives us the leeway to review as many of the critical incidents higher, tempered with the fact that we have limited resources and limited time. But that's the scope of what we're supposed to review. Thank you to the wisdom of the General Assembly. We have in the statute pretty strong language regarding access to information. I don't anticipate us having any problems obtaining the information we need to make timely decisions and decisions with a full body of information. There will likely be some bumps in the road as we're a new commission, and they'll receive a letter from me that says, hey, we need to look at XYZ. And they're going to say, I don't know who Craig Hargrove is. I'm not sending you anything. I'll send them the statute in a nice letter, and then we'll go from there. But I don't believe there'll be any substantial hiccups regarding obtaining information. All the information that we obtain, it remains confidential. If it was confidential when they sent it, it's confidential when we receive it. Everyone's required to sign a confidentiality agreement. And so everything is held in the utmost confidentiality. And because all that information is confidential, the statute lays out two basic ways that we are to meet. And so we have the statutory obligation to meet on a quarterly basis in an open meeting. So anybody and everybody can attend and listen to what we're talking about. But the statute also gives us the authority to have closed meetings because we have confidential information that is not redacted or lightly redacted, and we can meet as often as necessary to conduct our business. And so through the entire composition, you can see we have a phenomenal cross-section of individuals with various information and expertise that designed so that we can make the best decisions for our youth, the best decisions for the state of Tennessee and the youth justice system within Tennessee. And so that is the grand scheme of the Juvenile Justice Youth Commission Review Commission. And so now I will take any questions you may have. I'll do my best to answer those or get back to you with an appropriate answer at the appropriate time.
First, I want to thank you, Deputy Director Hargrove. I found that in my notes. I'm a little scattered today. So anyway, I really appreciate you being here. And, I can't say I enjoyed, but it was very educational to work with you with the DNM when you were in charge of that. So now Kylie takes care of that for us. So we've learned a lot in those, and I look forward to learning as much or maybe more out of this juvenile justice review. So thank you for being here today. Are
Thank
there
you,
any
Madam Chair.
questions for Deputy Director Hargrove? Well, I guess you did a really good job. So thank you so much again for being here, and I'll see you at the next meeting, if not before. How's that?
I love it. Thank you so much for your time and attention.
So, all right, so we're going to go back into session without objection. So seeing no further business without objection, we stand adjourned.